in the long term. When do you envisage, from that such framework could be developed and how it fits with what is being done now, noting the time pressures? Just like that clarification from your side, noting that we need to, one of the objects of the Act is the orderly development. And then when we talk about IPPs, whether private or public procurement route followed, where is the concern for the end user, ultimate end user? Where does all of this leave the end user? If you can just help me understand that. And I would appreciate on your last but one slide where you talk, I think it's the third slide before the last one, where you talk of alternative solution identified. If you may also assist in terms of that process of providing some insights or suggestions about what that alternative solution should actually contain. I think that will be useful. Thank you.
Thank you, Mr. Mkhize. Mr. Pokula. You might be muted, Mr. Pokula. Thank you.
Thank you, Chair. I was struggling to unmute. I just want to confirm my understanding of the proposal of the Energy Council. Is it that when we consider the discrimination and the objectively identifiable reasons and justifiable reasons, is the suggestion that we are going to look at each project and at each node and make decisions around the discrimination in that fashion, or is the suggestion that we would look at the bid window 7 projects and consider those to be the ones that justify the discrimination? I just want the clarity around that. Thank you.
Thank you, Mr. Pokula. Mr. Francis, maybe just one question from me. It's just a high-level question. That is, if the Electricity Regulation Amendment Bill were to be signed into law, would this application still be valid and required? Thank you. Oh, by the way, you as indicated to other presenters, you do have an option of only responding to those questions that you feel you are comfortable to respond to right now, but you have an option of actually providing written responses within 7 days. Please proceed.
Thank you, Chair. I will do my best to respond to them now, and I would, I think, like to take the time offered on at least one of those questions. So the first was, with regard to possible alternative solutions, when would we envisage it, and what would be the orderly development of that? So I think first to make a clear distinction as well on the mode by which we propose to try to co-create alternative solutions. We have this structure established whereby we coordinate business interface with NECOM. It is very inclusive. It includes members in addition to those members from the Energy Council. So it's not only limited to Energy Council members. It's a business structure, and it has been used to resolve several issues with regards to grid access over the past year. And it's been, I think, a refreshing change from the kinds of engagements in the past, and very, very helpful and very useful. So we would be hoping that it could be used with the existing structure to work on the fine tuning of, for example, the IG car and the process towards a codified version of that. And I am not 100% privy to the necessary internal Eskom timelines and steps for the approval of updates to that, or to, for example, the gated bulk generator application process. And Eskom would need to advise on that. And if there's anything that triggers, of course, a Section 21 approval in those cases, NERSA would need to advise. But we look forward to using the existing structure to explore some of the other thoughts on the table. Why? So I think that speaks to the other question. What are the processes for alternative solutions? I hope it responds to that. We have some that have been put forward and are currently being discussed with the technical committees that I've referred to. Why is it a concern for the end user was a question. So this is, I think, possibly a useful question to put to the different classes of end user, where you've got, for example, energy intensive users group, the Minerals Council, and you've got large users who look to procure on a bilateral basis versus the end user consumers at large, which also include that group, of course. I think they would be best placed to comment there, where their concern is, does it compromise their ability to procure directly and independently? I don't want to get drawn into the debate of which process serves the end user better. As I've said before, I think we recognize that both are needed in the interest of everyone. The question about are we proposing that you look at each project and each node versus looking at bid window 7? So here, to also be quite clear, what I'm saying is the more targeted the scope of such a decision is, the fewer stakeholders would be discriminated against, and hence the lower risk. This isn't a motivation that is the specific approval that is sought. What I'm saying is that if we looked at bid window 7 with that limited scope related to curtailment and to wind projects alone, then there's a lower risk of challenge. We're not suggesting a limited scope related to each project and each node, and I think there indeed there would be concerns raised around what are the kind of adjudication criteria you would apply for grid capacity allocation versus the adjudication criteria of a procurement. So that's, I think, sticky territory to get into. We're rather suggesting the second case is bid window 7 as a limited case. To Mr. Gumede's question, Chair, I must plead ignorance on the implications of whether this would.
Oh, we seem to have lost Mr. Jackson here for some reason. Hopefully it's not just on my side. Okay, he definitely was lost. Let's admit him back. Mr. Jackson, are you back?
I am. I was notified I was removed from the meeting. I'm not sure if I offended somebody.
No. Yes.
But yes, I have to plead ignorance. I cannot respond on the technicalities of whether, if the ERA is signed into law, whether this application will still be valid and required. I think we do hold out hope that within the tools and the rules that Eskom can develop, and as should be approved by NERSA where they trigger such approval, that we're optimistic there's solutions to this.
Thank you very much. As indicated, if perhaps you actually think any additional information that you may want to provide to us, we are would be more than happy for you to supplement your submission, which we do have a copy thereof. But if you want to maybe put any additional inputs based on the questions from members, we really appreciate that. We've got 7 days to do that.
Thank you, Chair.
With that, we'd like to thank you and apologies for being booted out. I don't think it was done on purpose. And we do apologize for that. With that, can we then move on to the next set of presenters? Two people, old colleague of mine, Ms. Yvonne Mfulo and Mr. Stuart Scott. On behalf of Envusa Energy, can I see both of you, please? And would like to swear you in.
Good morning, Chair.
Good morning, Yvonne. Anyways, it's great to see you, It's been a long time. And Mr. Scott, can I just ask, firstly, yourself, Mr. Mfulo, do you object to taking an oath or an affirmation?
No objection to that, Chair.
In that case, kindly raise your right hand and affirm the following. Do you solemnly declare that the information or the evidence that you are going to give to this panel is the truth and the whole truth?
I do.
For the record, please state your name and the name of the organization you're representing today and your designation therein, please.
Thanks, Chair. My name is Yvonne Mfulo, and I'm the Executive External Affairs Head for the Anglo-American Africa and Australia region. I'm here on behalf of Envusa Energy, a private jointly owned renewable energy venture between Anglo-American Energy Solutions Limited and EDF Renewable South Africa Limited.
Thank you, Madam. Can we then maybe move on to Mr. Scott? Mr. Scott, do you object to taking an oath or an affirmation?
Chair, thank you for raising that. So my name is Stuart Scott. I'm an advocate from the Johannesburg Bar. May I ask, can you hear me clearly?
Yes, I can hear you loud and clear.
Right. Sorry, it's a little bit awkward, Chair. Advocates are not allowed to take the oath, but I don't think there should be a difficulty because, of course, Envusa has taken the oath and I merely present legal points on their behalf. So in other words, I don't have any factual evidence to place before NERSA and myself.
Understood. Understandable. That's noted. So anyway, can I then come back to Mr. Mfulo? And I'm assuming that you are going to be making the presentation. And in that particular case, whoever between you is making the presentation, if you can then proceed, we've got 30 minutes as indicated, but as indicated previously, if you can do it in 20, it would be very appreciated. Over to you. Your 30 minutes starts now.
Thanks, Chair. I will be doing some introductory remarks and then hand over to Stuart for our submission. Just as background, Envusa Energy was set up for the purpose of developing and operating renewable energy projects to enable Anglo-American and the other large mining and industrial companies to reach their carbon neutrality targets while also contributing to the overall just energy transition. I'm sorry, somebody is trying to give me a Teams call, apology. While contributing to the overall just energy transition and in the South African public interest. Our assertion is that if Eskom's application is approved, the following unintended consequences would result. Firstly, we see the application as anti-competitive because projects that are ready to be constructed are not treated equally to be able to access the grid. This would effectively sterilize access to the most competitive wind projects for the commercial and industrial off-takers until Eskom grid enhancement plans are executed, and this is estimated to be at around 2029. It will also significantly impact their ability to reach carbon neutral electricity supply and their carbon neutrality targets. It will also prevent the country from benefiting from some almost ready additional capacity. And we expect that the energy availability will help catalyze extensive socio-economic activity, playing a critical role in unlocking South Africa's economic development and growth prospects. Secondly, the existing investment by private off-taker projects in the Western and Eastern Cape wind areas will not yield results, as I mentioned earlier, until around 2029, thereby affecting investor confidence and slowing down the development of renewable energy, which is so vital for bringing energy energy generation into the grid in the fastest way possible. For example, if you look at the project timelines for completion of Envusa projects in the area, these are around 3 to 4 years earlier than Eskom's, which means earlier realization of the benefit for the country. The other aspect is that international regulation and customer expectations that the mining industry meets its carbon neutral objectives mean that not meeting these would pose an existential threat to these businesses and the competitiveness of the exports, which are so vital for the broader South African economy's ability to access foreign currency payments, maintain and create jobs, and attract foreign direct investment. Greater industry focus on grid enhancement will unlock the pathway to faster energy development and transition, ultimately generation availability for the country, and not just for businesses as earlier mentioned. I need to make a point here, Chair, that all the additional generated capacity will end up in the system and benefit all South African and not just businesses. This is all from my end. I will not dwell into the legal merits of the matter and will hand over to Stuart to do such.
Right. Well, thank you, Chairperson, and obviously members of the panel. Envusa is, of course, very grateful for the opportunity to make the submissions. We'd also like to commend NERSA for the consultation document that you provided, because the specific questions really did assist in grappling with the issues that NERSA needs to grapple with. Now, one of the panel members asked a question about potential court applications. Now, what we've done essentially in our submissions and in our slide presentation is we tried to consider it from the perspective of, after NERSA has taken its decision, the point of view of a court considering any review application, whichever way that NERSA may take the decision. So if we could just go to the next slide. Right. So the question before NERSA is, should NERSA approve Eskom's application? And we respectfully submit, and these points have already been made in the presentation, the written submissions, is we submit that NERSA should not approve it for 4 reasons. The first reason is that the only 3 reasons put up by Eskom in its application do not objectively justify the discrimination. The second is that a decision by NERSA to approve the application would be irrational and unreasonable. And at the outset, I just wanted to make the comment that when we use terms like irrational and unreasonable, we mean it purely in the legal sense. So Envusa entirely accepts that Eskom, has a laudable objective to try and ensure the success of the government projects. So we don't mean any, malintent or anything like that. The third reason, as NERSA highlighted in the consultation document, Eskom should have got input from relevant stakeholders before approaching NERSA and placed that input before NERSA. The fourth is that Eskom's application raises, but does not deal with, various competition law concerns. Now, before dealing with each of those in turn, I just wanted to highlight, and we can go to the next slide, certain useful legal principles for NERSA to consider. Eskom's application needs to demonstrate that the discrimination is objectively justifiable. And NERSA, in considering the application, makes an objective determination. Now, the point I wanted to emphasize, and this is important, NERSA's determination must only be based on the evidence, facts, and points set out in Eskom's 12-page application, failing which NERSA's decision would fall to be set aside in any subsequent judicial review. So in other words, there have been a lot of points already made, some of which by Eskom and some by the other stakeholders. And the point is, if that information did not form part of Eskom's 12-page application, that is not something that can be considered by NERSA. And of course, NERSA is well aware of the various powers. I'm not going to go through those 2 points, Section 10 and PAJA. But what is important is that the only application that stakeholders had an opportunity to comment on were all the points in the 12-page application. So we can go to the next slide now. So now we're going to move on to our first basis why NERSA should not, in our respectful submission, approve. And that is Eskom's 3 reasons don't objectively justify the discrimination. So to Eskom's credit, and we really mean this, Eskom spends the bulk of its application, about 10 of its 12 pages, explaining the proposed discrimination, explaining that it's completely at odds with Eskom's legal duties under a range of empowering provisions, and how significant the discrimination would be. So, for example, Eskom itself admits that it seriously encroaches on the rights of private IPPs, and that it's not only discriminatory, but it undermines the promotion of competition. However, and thereafter, Eskom sets out its reasons for justifying the discrimination in just 3 short paragraphs. Now that's 11A to C. And our submission is those are, with respect, the only 3 reasons that NERSA can consider when it's deciding on this application. We can move to the next slide. And we'll demonstrate now, if I may, that each of these 3 reasons is entirely without merit. So the first point is that the first reason proffered by Eskom is that if IPP public programs fail, that will negatively impact investor confidence. Now, the point we wanted to emphasize is that that is precisely the consequence that will occur if the discrimination is permitted. So in other words, if discrimination sanctioned by the government for government programs, that will erode investor confidence. The second bullet there is important as well. Private IPPs, many of them have foreign investors. They've invested and concluded contracts for huge sums of money based on the legitimate expectation that Eskom will assign grid capacity in accordance with its empowering provisions. And there, I'm not going to go through them in detail, but Eskom, forthrightly, to its credit, admits that even the most recent IGCAR rules also envisage completely open and non-discriminatory access. So there's a real threat to the business of private IPP projects, and that in turn will have an adverse effect on the domestic economy as well as on investor confidence. And there's a reference there, of course, Chair, the panel will have the slides, and there are references back to where these points are made in each case in Envusa's written submissions. If we can go to the next slide. So the first reason is of no assistance with respect to the application. The second reason is that public procurement programs are not capable of competing with more agile, well-funded private programs. With respect, that is not so, and it's not so for 3 reasons. The first is that the law always permits state entities to abbreviate public procurement processes when there's an urgent need to do so. Eskom itself explains that there's an energy crisis, and I don't think anybody in the 172 people who are part of this Teams meeting would quibble with that. And indeed, the minister's determinations, each one of them, expressly refers to the possibility of deviations being necessary. The second point is that there are various examples of state entities running both lawful and expeditious public procurement programs. Now, I mean, just as one example, during COVID-19, for example, Stephen Budlander, SC, and I, we were advising the government. And what was incredibly impressive was how quickly everything moved. So we were having meetings at 10 p.m., 11 p.m., overnight the next day. Government representatives had produced documents overnight. So the point is, we do not accept as a general rule, and we do not think NERSA should accept that as a rule, procurement has to move slowly. And the third point that cuts against Eskom's application with respect is that the bidders are not public entities. They are the very same agile, well-funded private IPP programs and entities. So in many entities, in many instances, it may even be the same entities that are participating in public programs and private programs. So in other words, there's no reason they can't be ready first to secure grid capacity. So in other words, the second reason is not a reason that supports in an objective way a determination that the application should be granted. We can go to the next slide. So there's only one more reason that Eskom gives, and that is that Eskom is duty-bound to reserve and preserve grid capacity for public IPP programs. And Eskom, it's a little bit unclear, but they seem to suggest that Eskom's role as a designated buyer includes some kind of implied duty to reserve capacity. With the greatest of respect, that is simply incorrect. Now, Eskom's role as the designated buyer is entirely separate from its role as the sole guardian and gatekeeper of grid allocation. And our courts have made it absolutely clear that the same public entity can perform a variety of different roles. And what must be assessed is the particular function being exercised, not the identity of the functionary. Now, as an example that the courts have given, for instance, the president is both the head of the national government as well as the head of state. But when the president is performing the function as head of state, he can't just merely apply the legal duties that apply to him when he's the president. And with respect, it would be inappropriate to do so. And we can go to the next slide where we'll deal with Eskom in particular. So in other words, when Eskom is performing its role as the buyer under the government IPP programs, its duty is to timeously perform all of those roles as the buyer in line with the electricity regulations. By contrast, when Eskom is wearing its different hat, allocating grid capacity, it's obliged to follow the express duties that bind it under its licenses, the grid code, and even the IGCAR rules. And I've already made the point that all of those provide for non-discriminatory access to the grid. What's absolutely key in our respectful submission is that all of those documents include as a central tenet that the government's policy is non-discriminatory access to the grid. So Eskom's duty to support the government process can't override the government policy that all of those programs must still, in relation to grid access, be based on non-discriminatory access. And the further point is that Eskom's duty, even if we accept that Eskom had a duty to try and reserve grid capacity, and I've explained why that's not so, that shouldn't be misconstrued as meaning it needs to do anything and everything it can to ensure the success of government programs. The Constitutional Court has made clear that an organ of state can't achieve a correct or laudable outcome by any means. It has to follow the rule of law, and the rule of law in this case would include all of the detailed provisions that we've been speaking about. And on that score, if I could just refer to something, it's not on the slides, but it's just that the grid code itself, in the first place, it speaks about all the different stakeholders that were involved in constructing it. And I'll take you through a picture of it later. It also says that NERSA's role is to, via these various documents, to give effect to government policy. Now, government policy has been set out absolutely clearly in the various documents, and that includes Schedule 2 to the Act. Now, my colleague from Eskom this morning, he spoke of a tension between Schedule 2 and Section 34 to the Act. But with respect, there's also a tension between Section 21.2 and Schedule 2. And what I mean by that is discrimination under Section 21.2 that seeks to undercut Schedule 2 could never be objectively justifiable in the absence of an amendment to Schedule 2. So we can now go on to the next slide. So in other words, and with respect to Eskom, those are the only three reasons that should be considered by NERSA, and none of those reasons have merit. So in other words, Eskom has not demonstrated that the discrimination that they seek is objectively justifiable. For a variety of reasons, there are 4 of them, we say that if NERSA granted the application, NERSA's decision would in the first place be reviewable, and also it would be found to be irrational and or unreasonable for at least 4 reasons. I'm not going to read through them now because I'm going to deal with each in turn in the interest of time. So the first reason is that, if we could go to the next slide, the first reason is that if NERSA approves conduct that's ultra vires, that would be found to be irrational. So Envusa doesn't accept that Eskom is empowered to discriminate between the public and private IPPs. We set this out at paragraph 3.2.3 of the final submissions. And what's important here is when Eskom is performing its role, allocating grid capacity, every single one of Eskom's documents that bind it emphasize that it must give non-discriminatory and equitable access. So the ERA, its transmission license, the grid code, Schedule 2, the IGCAR rules, all of those say the same thing. None of these permit what Eskom is seeking before NERSA. And what's important is that there's no application, as been highlighted by others, for any amendment to any of these documents. And the second way we'd like to put this is that Eskom's application is at odds with what's called the principle of subsidiarity. And now this normally takes place in court matters by an applicant approaches, for instance, the Constitutional Court, and they try to rely directly on the Constitution instead of PAJA, for example, which has been enacted specifically to give effect to that. But there's another side to subsidiarity, and that is that a public entity can't bypass and ignore a host of detailed regulations and empowering provisions and codes, all of which amount to administrative action. And our courts have made clear that state entities are not permitted to ignore administrative action. All of those bind Eskom's powers, and it can't merely go past all of these detailed provisions by seeking to rely on Section 21.2. And I've made the point as well that we need to read the Act as a unitary act. We need to read it together, and discrimination under 21.2 could never be objectively justifiable when it's at odds with Schedule 2. So in other words, even if Eskom had the power to do so, which we respectfully submit it does not, it wouldn't be objectively justifiable for NERSA to approve it. The second reason, we can go to the next slide, is that there's no rational link with respect between Eskom's stated purpose and the means selected. I'm not going to go through all of this, but the central feature is that Eskom wants to support government's just energy transition objectives and government's programs. But as I've demonstrated, the central tenet of government policy that government has decided to incorporate into a host of documents, and it's been incorporated into acts of parliament, is that there must be non-discriminatory access. So in other words, the very purpose of the policy decision to open up electricity supply was to capitalize on the agility of the private sector. And Eskom's discrimination that they seek, it cuts against the first ready, first served principle that Eskom itself set out in the IGCAR rules. The underlying rationale of first ready, first served is important because it makes clear that it's not in the public interest for grid capacity to be held in abeyance while projects are not ready, they're still being finalized, there's going to be a huge delay, and we should instead focus on shovel-ready projects. Now, the important point is Eskom's application with respect flies in the face of that. The third reason that it would be irrational for NERSA to approve the application, and we can go to the next slide, is because various material facts have not been placed before NERSA. And here again, I emphasize that if a court is ever looking at this decision-making process, what it will be asking itself is what were the facts disclosed in the 12 pages that Eskom put up? What was the application that was made out there? So with great respect, some of the stakeholders had made reference to, for example, a limited application being approved by NERSA. That is not the application that's been made by Eskom. Eskom has sought a general application. So NERSA couldn't, with respect, approve only, for instance, an application for bid window 7. Now, NERSA itself highlighted in various places in the consultation document various material facts and information that Eskom has failed to place before NERSA. We, as well as Envusa, have highlighted various absolutely critical features that are not in that application. They're not dealt with at all. And with respect, that is absolutely fatal to Eskom's application being granted. And let me explain why. The reason is that the Supreme Court of Appeal, and this has been endorsed in many other decisions, this is now the 4th bullet point. This is an absolutely critical feature of this application. What the SCA has said is that if legislation empowers a functionary to take a decision, NERSA in this case, in the public interest, the decision should be made on the material facts which should have been made available for the decision properly to be made. A decision is reviewable if it's been made in ignorance of facts material to the decision. And what's important as well, and this is in the last bullet point, is that the Constitutional Court in the NERSA case relied on a single important fact that wasn't before NERSA when the decision was made, and that was Sasol's marginal costs. Now, the point I wanted to make is that NERSA itself and Envusa as well, and many of the stakeholders this morning, have identified not just one, not just two. It looks to be about 10 to 15 absolutely critical facts that have not been placed before NERSA. If we can go to the next slide, there's a 4th reason why it would be irrational with respect for NERSA to approve. And that is because the discrimination is not proportional. And I've touched on this a little bit again. Because what's important is that Eskom hasn't shown that there aren't less restrictive means available. And this was highlighted by the panel asking, has IGCAR failed? And the point is, and the point that the courts have made, is a sledgehammer must never be used to crack a nut. And we've explained, as have other stakeholders as well, that the proposed discrimination, and Eskom seems to accept this, would have grave effects on private IPPs. It actually proposes an existential threat to those businesses. And I know that our learned friend from Eskom this morning said that, well, it's not such a significant thing because it's only in respect of a few places that we want to have this discrimination, and the rest of the country will be open to the private sector as a whole. But with respect, as everybody in this virtual room knows, the very areas, for instance, for wind, the Western Cape, the Eastern Cape, those are the places that everybody wants access to. So it's of no assistance to say you can have access to all the places that nobody wants access to, but none of the access to the places that people need access to. And now what is absolutely critical, and this relates again to the last point, Eskom in its application had to demonstrate the alternative measures that it had considered and why they had failed and why this was needed. It needed to, if it wanted to, tailor its application only to bid window 7, or, for example, only to a certain capacity of bid window 7, but it's done none of that with respect. What Eskom has sought before NERSA is, I use the term loosely, but a blank check, essentially, for all public programs, once they are contemplated. And that would apply to bid windows 7, 8, up to 100, as many as are contemplated. Now, that in our respectful submission means it hasn't demonstrated that it's the less restrictive means. And if NERSA were to approve the decision, it would be likely to be set aside in any judicial review process. On the next slide, and I can go briefly through these last 2 points because I see that time is running short. This point is that Eskom failed to get input from relevant stakeholders before approaching NERSA. And that's highlighted in NERSA's consultation document. And with respect, it's absolutely correct, because Eskom's decision, as well as NERSA's decision, they both amount to administrative action, and therefore the procedural fairness duties in sections 3 and 4 of PAJA would apply. Now, what's absolutely critical, and this is what I've dealt with in what we've dealt with in the 5th bullet there, it would be truly extraordinary for NERSA to grant Eskom's application in the absence of any evidence that Eskom engaged with the ministers, with the Competition Commission, with other relevant role players. We have no idea with respect on the application before NERSA in the 12 pages that NERSA needs to decide on, whether the minister agrees with this strategy, whether any of the other stakeholders were approached, whether they were approached and rejected the idea. None of that was placed before NERSA, and it's too late with respect for that information to be gathered at the moment, because stakeholders only had a 30-day opportunity to comment on what was contained in Eskom's application. So in other words, if NERSA wanted to take into consideration other features and factors, NERSA would need to publish a new consultation document setting out any of those factors. But what NERSA today is called upon to decide is, in Eskom's 12-page application, has it set out all of the evidence, facts, and points for the application to be approved? And we respectfully submit that it hasn't. And an absolutely critical feature I'd like to emphasize again is that the high policy by government at the highest level is that there should be non-discriminatory access to the grid. So it would, in our respectful submission, infringe separation of powers if Eskom were permitted to bypass all of the detailed documents that I've taken you through, all of the empowering provisions, which Eskom itself accepts do not empower it to discriminate, and in a sense, bypassing those without amending them by relying directly on Section 21.2. The last point, and we can change the slide, please, is that Eskom's application raises, but doesn't deal with, various competition law concerns. Now, what's important here is that Eskom itself, again to its credit, recognizes its dominance in the market and that the application will stifle competition. Now, in competition law speak, and we've dealt with this in detail in VUSA's final written submissions, and it's at paras 4.4 to 4.4.5, and it's quite a detailed section. But the gist of it is this. There's one grid. All IPP projects, public and private, need access to it. In competition law speak, it's an essential facility. And Eskom is a dominant firm as the sole caretaker, and it is also a competitor, and we've explained exactly how that works in our submissions. And the critical feature is this. In the Competition Act, if you deny access to an essential facility, it's what's called a per se contravention of competition law. In other words, in some instances, you can show efficiency factors to justify something that seems prima facie to be precluded by the Competition Act. But you can't do that with a per se contravention. And if we can go to the next slide, we've already explained, and Yvonne
which I'm hoping it is the second, because you've taken the full 30 minutes.
I beg your pardon, Chair. If I could have a minute and a half to wrap up.
That's fine. That's fine.
Thank you, Chair. I'm indebted. So the important feature is that we've noted the chilling effect that this will have on private IPPs. And I'd just like to emphasize the last bullet point. So there's an asymmetry that NERSA should please consider, and that's this. NERSA shouldn't grant the application unless NERSA is satisfied that the competition law concerns and the discriminatory impact have been fully dealt with in Eskom's application. If it has any doubt on that score, the application should be refused. But NERSA can refuse the application without those detailed steps being taken. And that's because Eskom has the burden to show that the discrimination is objectively justifiable. And now if we just, I think we could skip the next slide. Yeah, that's perfect. Yeah, that one. So this is just an extract from the grid code, and this is going to be my final point, Chair and panel. I'm indebted to the time. The grid code makes it absolutely clear how detailed the relationship is between all of the different bodies. And these were the people who put together the grid code. And you'll see at the top, there are the three departments: trade and industry, public enterprises, minerals and energy. Now, all of them have ministers. Then at the second level, there's NERSA. And what's interesting is that NERSA and the Competition Commission are on an equal playing field. Now, there's been no showing at all that these competition concerns, which will have a detrimental effect and indeed could pose a real threat to private entities in the IPP space. There's no showing at all in Eskom's 12-page application why the competition law concerns have been dealt with. And for example, just a final point, Chair, is that one of the panel mentioned, if there was going to be an amendment to the grid code, surely the grid code advisory committee would be involved. That's absolutely correct. If the act needed to be amended, Schedule 2, Parliament would be involved, the public would be involved. And if government policy is going to be amended, then surely the ministers need to be involved. But none of that is before you. And just to conclude, that we've made the points, I'm not going to sum them up again, we can go to the last slide. But the essential point is, for all of these reasons, NVUSA respectfully submits that in relation to the question before NERSA, should it approve Eskom's application in respect of the blanket way it's been drafted by Eskom, and we respectfully submit that it should not. Thank you, Chair. I'm grateful for the additional time.
Thank you, and thank you for your legal inputs as well. So, members, you've got a presentation from NVUSA. Any questions? I know there's a question on there which was sent by email, but I'll only read that in the event that members don't have a question. Any question from members? Okay, it seems like Mr. Mkiza, if you can go ahead, sir. Maybe you can also expand on the question on the chat, on email as well. Thanks. Mkiza, you are muted.
Oh, thanks, Chairperson. Thanks to Madam Fulo and Scott. From my side, I think there are two questions, including the one from the member of the public. It's when one looks at slide 2, the last bullet, how do you marry this with section 21.4c? I'm saying this because section 21.4c states that access in terms of subsection 3 must be provided on the conditions set out in the license of such transmitter or distributor that may relate to the strengthening or upgrading of the transmission or distribution power systems in order to provide for access, including contributions towards such upgrading by the potential users of such system. Just your reflection on that in terms of particularly the issues around contribution towards such upgrading by the potential users of such system, if a long-term view is taken in particular. The other question was on how can emergency procurement be justified in the context where it is not feasible to run a tender process because of lack of grid capacity allocation. I think you did talk to the anti-competitive elements, but the issue is, how do you look at anti-competitive elements in circumstances where the same players participate in the public procurement and the private offtake arrangement, as the same participants have an opportunity to participate and do not seek to exclude participation by any party. Furthermore, this is being undertaken by Eskom in its capacity as a network grid provider and not as a generator. I will leave it at that. Thanks, Chairperson.
Thank you, Mr. Mkhize. There being no further questions, can I then hand over to both yourself, Mr. Mfulo and Advocate Stewart? Over to you.
Absolutely, Chair. And may I make a practical suggestion as well as a request, and it would be this. So I, of course, have presented Envusa's written submissions based on, engagements with the client. I don't want to speak out of turn in relation to those 3 questions. So I think probably the most appropriate thing would be for us to submit our answers in writing, because I don't want to say anything. I don't have instructions on, for instance, Envusa's attitude towards 21.4C. But can I also make a practical request, Chair, and that is that we might be able or permitted to submit our written responses 7 days after Eskom has provided its written responses. And that's just because, of course, Eskom's the applicant, and if it raises anything new, we would want an opportunity to deal with that from a process fairness perspective.
Okay, maybe just to respond to that request, firstly, as you know, that the responses that will be sent by Eskom will be directed to NERSA to supplement their own input. So not necessarily shared, and you may object to that, but not necessarily shared with the stakeholders. But the stakeholders would actually see that in the final decision that NERSA would make, because we'll actually publish all of those responses in the reasons for decision document. But secondly, there's a practical aspect of this. We do need to make a decision within a prescribed time frame, and therefore we do have we are trying to schedule meetings to be able to make that decision. So if it's okay, I know it might not be optimal, Advocate, but we would really request that all of the submissions be made in the next 7 days, so that we can then be able to be in a position to consolidate all of them, because it's also combined with anything else that we may have submitted before. We really, maybe it might raise other challenges, but we would request that, because we are actually targeting to actually have this matter come before the subcommittee of the board in the middle of this month still. If that's okay with yourselves.
We completely understand. I wonder if as a compromise, so assuming that the panel thinks that we should be able to see Eskom's response, and we would be very grateful to see that, we could submit our response sort of a day or 2 after Eskom's response. So in other words, instead of 7 days, we could submit it, the very next day, or 2 days afterwards. So in other words, we don't want to compromise the nurses' time. We completely accept that. We just wondered if we might be able to have sight of that. And that just means, and again, we just want to assist NERSA in reaching its decision. So for instance, we would be very grateful for an opportunity to comment on anything Eskom places before NERSA.
Noted. We are, as you know, we are governed by our own internal rules as well and procedures. But I see Mr. Mkhize would like to comment on that, Mr. Mkhize. Sure. But firstly, on your earlier request, it makes sense that you then need to get guidance and input from your client before you actually submit. So that makes a lot of sense. Mr. Mkhize.
Thank you.
Thanks, Chairperson. I think the concern is valid, but Eskom is not necessarily going to introduce new things, but more to expand on what they have provided, to augment what they've provided. If there's something really diametrically opposed to what they've provided or very different, that then will open up for sharing of such, so that there can be further comments on that. So I would then implore that the 7-day window period be still utilized for sake of this process running smoothly. Thank you.
Thank you. And also perhaps Eskom may assist and actually submit their comments before the 7-day period. But yeah, that could help.
Thank you, Chair. So we are indebted, and so in other words, we are happy to go along with the 7-day period. We would still, of course, we appreciate that the NERSA will make a call on whether to share Eskom's submissions with us, but we will endeavour to respond, of course, within the 7 days.
Madam Mfulo, your last words?
Yeah, I'm good, Chair. We had not considered the question since Eskom had not proposed that. So we will need to go back and look into this, and then we probably would be able to respond. And I'm happy with responding to the 7 days. Thanks.
No, thank you. Thank you very much for all your input, especially all in terms of the legal guidance. It is much appreciated. Thank you, Envusa, on behalf of NERSA. So if we can then step off the Envusa input and go to the last presentation of the day from the IPP office.
Thank you, Chair.
Lina Mangodo. Thank you. Thank you. Madam Mangodo, can I see you? Oh, I see you. Welcome. Before we start, as you know, it's customary to ask these questions. Do you object to taking an oath or an affirmation?
Good afternoon.
Okay, yes. Now
Good afternoon, Chair. I have no objection. Thank you, Chair.
In that case, kindly raise your right hand and affirm the following. Do you solemnly declare that the evidence or the information you're going to give to this panel is the truth and the whole truth?
Yes, I do.
For the record, please state your name, the name of the organization you're representing today, and your designation therein, please.
My name is Lina Mangondo. I'm from the IPP office. The IPP office assumes responsibility on behalf of the department for implementation of the IPP procurement programs. I do have the relevant authority to represent the IPP office in the representations that we make today.
Thank you so very much. You've got your 30 minutes. If you can, then I'm assuming that you've been given rights to present. If you can show your presentation and proceed with it. Thank you.
Thank you. Thank you very much. Can you see it on the screen?
Yes, it is visible. We can proceed now.
Okay. Thank you. Firstly, I would just like to provide context of the role of the IPP office in the IPP procurement programs. The IPP office is essentially mandated to implement the IPP programs pursuant to the ministerial determinations made with the concurrence of NERSA in terms of Section 34(1) of the Electricity Regulation Act. It's important to note that through the IPP program, new generation capacity is procured, which is implemented through a public procurement process in line with the requirements of our public law. This procurement is undertaken to ensure security of supply for the benefit of all electricity consumers and hence protects the broader consumer base. This is done in the best interest of the public. Under the current circumstances of grid capacity constraints, the public procurement and its public benefit has been negatively impacted. It is thus important that there be a balance between broader public and private sector interests in the manner in which grid capacity is allocated going forward. The outcome of the procurement concluded by the IPP office on behalf of the department has been to secure competitively priced electricity, and there's been a downward trajectory in the electricity prices, which ultimately broadly benefits all electricity consumers and such is also key, is a key input into the economy to drive economic growth. The key interest in this respect for the IPP office is to ensure the successful implementation of the Section 34 determinations and outcomes of current and future IRPs. Additionally, is the public interest and benefit of the new generation capacity, which is established for the broader consumer base. The need to ensure compliance with public procurement prescripts, which underlines the procurement processes that we follow, and need to ensure equitable share and distribution of the limited grid resources between the public sector and private sector opportunities, thus achieving a balancing act relative to the proportionality of contribution and advancing the interests and benefits to the broader consumer base versus those of individual off-takers. I'd just like to again highlight that is the important distinction between the public procurement and the private off-take arrangements, in that the public procurement ultimately benefits all end users as consumers, whereas the private off-take arrangements benefit a select few on a bilateral basis based on the terms and conditions of the commercial arrangements that they would have entered into. I thought it's just important to highlight what the procurement program has achieved thus far. From 2012, a number of 9 bid windows have been procured since the inception of the program, with 7,335 megawatts operational from 95 projects. I must also mention that we've got 2 peaker projects of 1,005 megawatts, and we currently have 1,183 megawatts of projects currently reaching commercial and financial close. Of since the inception of the program, 139 preferred bidders have been appointed, with a total capacity of 12,417 megawatts having been established. 1,897 megawatts are currently in construction, and currently there's 8,231 capacity that is currently in the market. Those are RFPs that are currently in the market, which are to be evaluated and announced in the 2024-2025 financial year. I think it's important to note what precipitated this whole initiative. The department launched bid window 6 with the intention to procure 4,200 megawatts. However, of that, 3,200 megawatts of wind capacity could not be appointed due to lack of grid capacity. Since inception, the IPP program has contributed 114,598 gigawatt hours of electricity and has contributed to alleviating at least 2 stages of load shedding. Aside from the contribution that the program has to ensuring security of supply, the program seeks to achieve and has advanced various national economic and social economic development goals and objectives, which include job creation through employment opportunities created for South African citizens during construction and operations, key to meeting our climate change and emissions reductions commitments. The program has offset 106.2 million tons of CO2 offsets through the REAP program. Significant contribution to participation by Black South Africans in these projects from a equity perspective, you have 39.4% of shareholding by Black people. In the projects where where the projects are located, the local communities have also benefited through shareholding, an average of 9.2% shareholding achieved there. And also from a local content perspective, it's contributed 73.5 billion rands, which amounts to around 49% of total project value. From a SED and enterprise development perspective, the actual contribution has been 3.5 billion rands. It has had significant water savings associated with the program, leading to 125.5 million kiloliters being saved. And for Triple B in general, there's been a 90.1 billion rand of expenditure to date, thus having a significant contribution to the broader economy and economic benefit. Needless to say, that we now have a vibrant energy sector, as on the backdrop of the IPP program, which essentially enabled that to be established. Just to give an overview, I will not go into numbers. As I indicated earlier, you see that progressively over time, there have been significant reduction in pricing associated with the IPP program, which through the competitive process has broadly benefited the consumers. I would like to now move on to the policy context of the IPP program. The IRP 2019 contemplates that, amongst others, in the period between 2022 to 2030, 1,600 megawatts of additional wind capacity would be established. Now, to enable the achievement of the IRP objectives, the minister issues ministerial determinations with the concurrence of NERSA. I previously spoke to this in my intro. I'm not going to go any further into that. The ministerial determination, including in relation to the required new generation capacity, the buyer of such new generation capacity, and procurement thereof, which is all set out in the determinations themselves, constitute administrative action which is binding on Eskom, which is binding, including on Eskom as the buyer, until reviewed and set aside by a competent court of law. So they have external legal effect and are accordingly binding. In terms of the current ministerial determinations, the department is appointed as the procurer, and as the procurer mandates the IPP office to implement the IPP programs on its behalf. Eskom is legally bound to purchase new generation capacity from preferred bidders as appointed by the department following the procurement process as contemplated in the determinations and further provisions of Section 34(1)(e) of ERA. In the context of administrative action, it's important to note that bidders expend a significant amount of funds upfront to get their projects ready to bid. In terms of Section 1951G of the Constitution, there's a requirement for transparency in all public administration to be fostered by providing the public with timely, accessible, and accurate information. Eskom, including its subsidiaries, we talk broadly of Eskom, and where the context requires it's the relevant section and subsidiary of Eskom. Eskom is a general reference. Eskom, thus being aware of the procurement process and the determination made by the minister, is enjoined to ensure that the ministerial determination is not rendered nugatory and the procurement process is not undermined. Particularly, the constitutional rights to procedurally fair administrative processes by bidders are not infringed. In an environment of material grid capacity constraints, Eskom has to balance its obligations in the management of the process for grid allocation in a manner which is fair and consistent with all of its legal obligations, including its obligations as the designated buyer under the ministerial determinations and its obligation to facilitate non-discriminatory access as the network service provider. The Section 34 IPP programs are procured publicly and are open to all to participate. No one is precluded from participating, and furthermore, the new generation capacity that is procured is available to all classes of customers as part of the consumer base. Hence, the preservation or reservation of capacity for procurement of new generation capacity pursuant to a Section 34 determination cannot be considered as constituting discrimination between customers or classes of customers or between third parties regarding access as contemplated in Section 21.2 and 21.3 of ERA. The reservation is not in violation of the provision of these provisions, and failure to comply with the administrative action or the executive action referred to above will in fact expose the minister, the department, and Eskom to litigation, which may result in the delay of the implementation of the objectives of procuring new generation capacity and would have undesired financial implications. Eskom, having issued the GCCA upon which a bid window of the REAP is based, and being aware of the procurement process which follows, is enjoined to ensure that the applicable determination is not rendered nugatory and the procurement process is not undermined, and in particular, the rights of bidders, the constitutional rights of bidders to a procedurally fair administrative process are not infringed. It is imperative that NERSA takes cognizance in its decision-making of the broader national energy challenges to supply power to the general consumer base, which is the underlying objective of the IPP programs conducted pursuant to the ministerial determinations. Private offtake IPPs are welcomed as a measure to alleviate the electricity supply constraint. However, these bilateral deals do not serve the broader consumer base and the interests of South Africa as a whole. Given all of the above legal and policy considerations, the IPP office believes the measures proposed or implemented by Eskom to ensure the allocation of additional grid capacity made available under curtailment in the 2025 GCCA addendum to bidders in the REAP program would be considered as reasonable and defensible under these extreme grid constraint conditions, and as being consistent with Eskom's obligation as a buyer under the applicable ministerial determinations and not offending the requirements of non-discriminatory access. Without Eskom and NERSA's cooperation to facilitate an immediate solution to enable bid window 7 bidders under the REAP using onshore wind technology to secure grid capacity allocations in the Western and Eastern Cape, the risk of procurement failure for bid window 7 onshore wind technology is high. This is an unsustainable outcome for South Africa as it undermines the balance between wind and solar PV as contemplated in the IRP, enclosing the supply shortage gap, thereby resulting in an imbalance in the supply options and further undermining the fundamental tenets of the IRP that seek to achieve reliable access to affordable electricity by the public, which is a critical tool for directly and indirectly addressing South Africa's triple challenge of addressing unemployment, poverty, and inequality. As an outcome of bid window 6, the department was unable to appoint preferred bidders for wind due to the fact that the grid capacity, which was indicated in the CELs provided to compliant bidders, being no longer available during the evaluation stage of the procurement phase, which effectively disenfranchised the department and rendered the ministerial determination a nugatory. To alleviate this and further erosion of market confidence in the REAP program, the IPP office spent a significant amount of time in 2023 engaging with Eskom on the development of other grid enablers to enable actualization of capacity and to ensure that the program will be able to, future programs will be able to be successfully rolled out. This also included looking at curtailment, the preservation of grid capacity through the gated grid connection process, and the grid capacity allocation rules. These additional enablers sought to solve for multiple procurement programs by private IPPs and public IPPs running concurrently and competing for the same limited grid capacity in an uncoordinated manner, and also to prevent arbitrage by participants in the market between the two separate and independent processes. Until medium to long-term expansion and other measures to strengthen the physical transmission infrastructure is in place, immediate short-term measures to enable the orderly allocation of grid capacity for the REAP is needed. It was recognized that curtailment was an essential element to enable additional wind generation in the country, and that given the tight system capacity constraints, the implementation of such framework was urgent to release capacity. Hence, a procurement framework was implemented for bid window 7 in anticipation of the updated GCCA to optimize costs and to mitigate against the market pricing the cost of curtailment into the bids for the 20-year PPA tenure, for which the consumer would have to pay from day one. The consequence of this is that when curtailment is applied by the system operator, deemed energy payments are made by the buyer, and the cost of these payments is a pass-through and ultimately paid for by the broader consumer base as part of Eskom's cost recovery under the tariff. As such, this should entitle the same broader consumer base to benefit from the grid capacity, which is unlocked through curtailment, as this otherwise burdens the broader consumer base in an unfair manner. If there's no supporting procedures in place as part of the CEL and BQ process to ensure that bidders in bid window 7 can access the additional capacity that has been made available in the Eastern and Western Cape under curtailment, there's a risk that the broader consumer base and the public IPPs will not be able to benefit or access this capacity. An orderly system of grid allocation manages the arbitrage that has taken place in the market by market participants between the public procurement program and private offtake opportunities. The introduction of IGCAR was, as we understand, further aimed to level the playing field between IPPs participating in the public sector and IPPs conducting private offtake arrangements, through the establishment of fair and orderly queuing system for grid capacity allocation. And IGCAR, unfortunately, IGCAR on its own cannot solve the problems experienced in bid window 6. In the long term, this will require that an appropriate regulatory instrument be put in place. It's important to note that the framework that is currently under consideration, capacity reservation or preservation, while it is contemplated to be applied in bid window 7, will not be limited in its application to that bid window, but will apply to future bid windows. The key challenges which face IPPs participating in the REAP relative to those conducting private offtake arrangements are that because of the manner and the requirements that are set out in the public sector procurement legislation and legislation and regulations which mandate a fair competitive process which is open to all qualified parties. Prospective bidders must be given sufficient time to prepare their proposals so that the proposals are comprehensive and reflect a final offer capable of acceptance by the department or Eskom, and that all necessary governance approvals and checks be completed before preferred bidders are appointed. This also the manner in which the qualification criteria have been set is to ensure that you are actually getting robust and ready projects that are ready to implement. And from a government perspective, when we go out to the market, the RFPs already contain the relevant agreements with risk positions having been settled with the buyer, and the government support already having been settled, which limits scope for negotiations to settle contract terms, and hence you from both the bidders that bid and government, you have you have significantly advanced projects and project agreements which enable parties to, based on obviously still the commercial processes that have to be undertaken, to achieve commercial and financial close within the quickest possible time. However, this puts, because of the need to comply to legislative prescripts, this puts the public procurement at a disadvantage. This discrepancy between the experience of public sector IPPs and those transacting entirely in the private sector is what necessitates special measures being provided for, so as to ensure that both can participate in the generation sector on more or less equal footing and ensure there's equitable share of the limited grid capacity by the private off-taker and the broader consumer base. Without Eskom's proposed grid preservation and or reservation proposals, IPPs participating in public procurement programs are effectively disadvantaged from securing grid capacity allocations. The reason for this being that the regulatory requirements for public procurement is such that any available grid capacity in congested areas will be taken up by private off-takers, which need not go through the same procurement and approval processes. Thus, the proposed mechanism is actually not intended to limit competition, but to ensure that public procurement programs can succeed and continue in the public sector, notwithstanding the agility and other advantages enjoyed by private sector developers and buyers. Therefore, we do not view the measures proposed by Eskom as seeking to prohibit or preclude private offtake IPPs from participating in the electricity supply sector. Instead, the effect is to ensure that the sector develops in a manner which is consistent with government policy and the objects of ERA, and that the additional grid capacity made available by Eskom through the application of the curtailment regime can be secured by bidders in bid window 7 and other IPPs for supply to the general consumer base, which will bear the cost of curtailment through Eskom's regulated tariffs. In other words, the implementation of these measures is, we believe, in the public interest and should be supported by NERSA. Eskom, having issued the GCCA upon which the bid window of the REAP is based, and further its proposed measures to effect grid preservation for purposes of the REAP, and the implementation of these measures are consistent with its obligations under ERA, its transmission and distribution licenses, the grid code, and the ministerial determination. Additionally, the public sector procurement legislation and regulations mandate a fair competitive process which is open to all qualified parties, and prospective bidders are given sufficient time to prepare their proposals so that the proposals are comprehensive and present a final offer capable of acceptance by the department or Eskom, and their necessary approvals and checks before preferred bidders are appointed. In circumstances where the grid capacity is constrained and demand for access to the grid exceeds available supply, there must be some systematic and logical mechanism for working out how to apportion the available supply fairly. For as long as the constraints exist, as I indicated, the broader South Africa consumer base is disadvantaged. At the commencement of the procurement process, the grid connection capacity, which is required for purposes of the bid window in question, should be preserved for purposes of the procurement, and consequently be regarded as unavailable for allocation by Eskom to third parties until the procurement process has run its course and preferred bidders have been appointed.
Can I disturb you? Can I ask that you conclude, please, ma'am? I don't know how far you are with your presentation, but you've run the course.
Okay. The IPP office does not agree with the statement that Eskom should have applied for exemption from the requirements of the new Gen Regs or an amendment thereof in order to...
Colleagues,
Sorry.
as requested, Mr. Mashian, as requested, please mute yourselves and also your mic, your videos, please, colleagues.
Okay. The IPP office does not agree with the statement that Eskom should have applied for exemption from the requirements of the new Gen Regs or an amendment thereof in order to preserve or reserve grid capacity for public IPPs. There is no provision in the regulatory framework for obtaining an exemption from a ministerial determination. An exemption from and or an amendment to the new Gen Regs would not achieve what Eskom is seeking in respect of grid preservation and a reservation, and therefore neither are appropriate legally permissible solutions. In terms of Section 10(1)(b) of the National Energy Regulator Act, every decision made by NERSA must be in the public interest, given the importance of ensuring adequate electricity supply to the general consumer base, rather than favoring individual offtake customers. The special measures proposed by Eskom are warranted and indeed necessary to limit the impact of an uneven playing field and no access to the grid by the private sector programs. Thank you.
Oh, thank you. So you are close to the end of your presentation. Thank you, members. You've got the presentation before us. Any questions to the IPP office? By show of hands. Any takers? Doesn't seem like there is any taker. Mr. Nkiza.
Thanks, Chairperson, and thanks to Madam Makondo for the presentation. Again, I would still ask the question of saying, where is the concern regarding the end users reflected in all of this? As that's the first one. And then secondly, is there a way of incentivizing generation where or connection to areas that are not congested instead, in trying to deal with the grid capacity challenges. And then I looked at your policy and regulatory context, the slides. Would it be Eskom rendering nugatory and undermining the procurement process, or really a failure by the IPP office and the department to do its own homework to ensure that key success factors are duly considered and taken care of? That's one slide where you've got that aspect as a last bullet, and then we seem to be juxtaposing the two. And my concern is, in other the private and public IPPs. But it's not so clear as to what actually is the way that best serves South Africa, especially end consumers. And then you stated that the public IPPs are like disadvantaged. But I'm not so clear as to in what way they are disadvantaged by the current modus operandi, requiring them to be put on the same footing and not necessarily be given a slight advantage. Because if we go back to the rules, they're saying first come, they're on a first come, first served basis, but they should be shovel ready. That is what I understood it to be saying. And by having these, complying with those rules, why should it be a problem? I just want to get clarity on my side. Thank you.
Thank you, Ms. Mahmoud. I was hoping that you were taking notes. I wasn't seeing you writing, but perhaps you'd remember the questions. I just one question from my side, just a general question. Does it matter in respect of the IRP or even in terms of the public interest, who supplies the wind energy? Does it matter if it's supplied by the private IPPs or by the Section 34 IPPs? Anyway, those are the questions to you. Remember, the offer still holds. You can respond in 7 days. You can choose the ones that you want to respond to today, and can provide written responses, even to supplement your off-the-cuff responses as well. Over to you, ma'am, if you can respond to those questions.
Thank you. Also joined by Mr. Magoro, so he can supplement to the extent that he feels the need to supplement. I've sort of clustered. I note the questions that have come through, but to a certain extent, I believe my response, my remarks now, should cover all of the questions. I welcome the opportunity to supplement. Should I miss anything in my response? I think when one considers the IRP, the IRP obviously did consider both, opportunities that could arise from private sector opportunities, as well as, should I say, from a supply-demand balance, the interventions that needed to be put in place to ensure that there was sufficient capacity, and that IRP over and above the other initiatives. I think at that point it was embedded generation. Please, if I've got it wrong, please excuse me in that respect. But in that respect, there was a very definite policy need and objective expressed to get 1,600 megawatts of additional wind capacity established on an annual basis from 2022 to 2023. To achieve that, the ministerial determinations were issued, which ministerial determinations expressed a need for procurement in of new generation capacity, which included wind and PV. Presumably, in that determination and the concurrence by NERSA, there was a consideration of the public interest, and certainly in the third determination, the Schedule 2 had been promulgated, so there would have been a consideration as to whether there was a need for this procurement or whether to just allow private sector initiatives. We are not juxtaposing public and private procurement against each other. In fact, they are complementary. It's not one or the other. There's a recognition that there's a place for both. However, in relation to the grid, it is not so much about generation. The two are not in contention. The issue is around whether the grid, the grid capacity constraints are being currently fairly allocated, recognizing the process and timelines for each of the two programs or initiatives. They don't run the same course, primarily recognizing that for public procurement, there are certain public procurement prescripts that we cannot undermine in seeking to undertake public procurement. I wouldn't say that necessarily there's a failure by the IPP office or the department. We currently just have a grid capacity constraint, which all parties are seeking to manage. In relation to the end user point, the IPP procurement programs seek to procure in the interests of the broader consumer base and effectively benefit the end user or end users without classification of the types of end users. I don't know if there's anything I've missed. Thank you.
I think in your broad response, you have responded to all the questions. Perhaps again, as you review your responses, you may find areas where you might want to supplement. I think that's when we can take the opportunity to add further information in that regard. Unless there's something else that you may want to add, Madam, we would like to excuse you and thank you on behalf of NERSA for the presentation that you made to us. As indicated earlier, I know it is 13:25 already. We are an hour and a half over the time that we had allocated to ourselves, but we would like to give Eskom 10 minutes of right of response. If Mr. Setwana, you're still up to taking that that opportunity, we want to avail it to you. If you can then maybe switch on your camera and we afford you 10 minutes time to actually respond. Thanks.
Chair, thank you. I hope I am visible on the camera.
Yes, you are visible and audible.
Okay, Chair, let me start off by thanking all participants, members of the public, our fellow presenters who came and contributed to this process. On behalf of Eskom, we welcome all contributions. And from our side, we have presented the application on behalf of Eskom. But what was more important for us was to present the challenge that is faced by the industry and to invite other industry players to come on board and to find common win-win solutions for the industry. Our understanding of the process, Chair, is that this is not an adversarial process. This is a process where all industry players are invited to come together, acknowledge and appreciate the challenges that are facing the industry and find common solutions. We have proposed a solution in the form of grid reservation and preservation that will ensure that there is peaceful coexistence, if I can put it that way, between the private sector procurement and the public sector procurement. And we believe that those two programs can coexist and they can thrive if the application that we have submitted is granted. We also believe that in our current context, there is room for the public procurement process to continue to operate. And we think it should be given an equal footing. We are also working, as I pointed out earlier, on other initiatives such as wheeling, portfolio wheeling, to also ensure that our private customers also thrive. So in conclusion, Chair, I just wanted to thank all participants. I think we will take the opportunity to supplement some of our submissions, our 12-page submission. We will supplement it, Chair. But we will also welcome the opportunity that those who participate must also find sustainable solutions for the energy industry, because that's our posture from Eskom, that we want all of our customers, our valuable customers, private and public, to succeed. And we want the end result and the shared objective, as I pointed out in our presentation of the key objectives, is to ensure there's energy security for the country, is to ensure that as South Africa we thrive, we create job opportunities, and we create a sustainable future for this country. So with those words, I want to thank you for giving Eskom this opportunity, Chair. Thank you.
Thank you so very much. Not just to yourself, Eskom, but I'd like to thank all of the presenters today and all of the contributors, actually, all of the people that have taken time to write to the energy regulator, because we've had a few, just trying to remember now what the number was. We've got 23 stakeholder comments that were received. So we really like to thank everybody who has taken time to actually contribute to this. I mean, the point is we raised, we need to have a solution. The idea here is that this is not supposed to be an adversarial process, as we have clearly indicated. So the idea is to find a solution. So we would rather request members of the public that they give us, they contribute towards finding a solution. And yes, there is no solution if whatever that we make it, if NERSA makes a determination that ends up in court for the next 3 years or 4 years, it doesn't really, that's not a solution. So we need a solution that is practical, that will assist the industry to actually take forward the process that this, in terms of what Eskom is trying to achieve. With that, I see there's a hand, but unfortunately we've come to the end of the day. And I really like to thank all the members of the public, all 177 of you that stayed the course, and all the members of the energy regulator and staff, and also people from Eskom. Thank you all, and may we then the members of NERSA, can we join immediately on the other platform as was agreed. Thank you and goodbye.
Thank you, Chairperson, and all attendees. Cheers.
Thanks, Chairperson and everyone.
Bye, everyone. Thank you. you.